only and not speak or participate. Can I please remind you all to switch your phones to silent for the duration of the meeting? In addition, can I refer you to the protocols for remote meetings which have been circulated, namely, firstly, your microphones should be switched to mute unless you are speaking. Should you wish to ask a question or make a comment, can you please indicate either via the chat function or by raising your electronic hand via Teams? I will assume that you have all read the paperwork before us today prior to the meeting. Please only use the chat function to indicate if you wish to speak as an alternative to the electronic hand function or to raise any technical issues. And finally, when asking a question, can you please indicate which page number you are referring to? Can I just add to that? I know it has been a little bit confusing because we've had the report come to us twice with different page numbers, but we will be tolerant and understanding. So the first item on the agenda is to do a roll call. I am Councillor Lynette Purcell, the Chair, and I am present. I will now call on Charlotte, the Democratic Services Officer, to take the roll call.
Thanks, Chair. I have marked you as present, so if I move to the Vice Chair, Councillor Charlotte Goldsworthy.
Present.
Councillor Arthur Davis. We've had apologies from Councillor Oliver Davis. Councillor John Miller. Councillor Miller, are you here? Councillor Suzanne Patterson.
Present.
Councillor Sonia Reynolds.
Present.
We've also had apologies from Councillor Dave Whitelock. Councillor Alwyn Wilcock.
Present, Chair.
Councillor Carolyn Edwards.
Present.
Councillor Wyndham Griffiths.
Present, Chair.
Councillor Helen Kerry Clark. Oh, sorry, Chair. I've also had apologies from Councillor Clark as well. Councillor Nicola Davis.
Present.
And then Cabinet members, Councillor Alan Lockyer. No. Councillor Peter Richards.
Present, Charlotte.
And then if I move on to Neath Talbot officers, Andrew Jarrett.
Andrew gives his apologies, Charlotte.
Oh, thank you. Angela, I'll mark you as present as well. Kerry Warren. Robert Davis.
Yeah, present, Charlotte.
John Hodges.
Yes, present, Charlotte.
Have I missed any Neath Talbot officers?
Gareth Evans is just trying to connect now.
Right, okay, no problem. And then if I move on to Titarian officers, Chris Edwards.
Yes, present, Chair.
Way.
Present, Charlotte, thank you.
Jackson.
It's just going to be myself and Chris this morning, if that's okay.
Yeah, that's not a problem at all. Chair, I'm aware that Councillor Arthur Davis, I think he's just struggling to access the meeting, so I'll get him in now in the background as well. But other than that, have I missed anyone at all?
Did we manage to locate Councillor John Miller, because he was here at the pre-briefing?
I will try and contact him as well outside the meeting to see if he can join as well.
Brilliant.
There we are, Chair. I think that's everyone.
Thank you very much for that.
Yeah.
Right, the second item on the agenda is Chair's announcements, and we have only one item to scrutinise today, which is Neath Talbot Council and Titarian Consultative Draft Lettings Policy 2021. Thank you. So the next item is the declarations of interest. Can you indicate if you have a declaration of interest by raising your electronic hand? Charlotte will circulate a declaration of interest form virtually for you to complete. Anybody? Now, that's a little bit of a problem because John Miller in pre-briefing did think he had a declaration of interest. If he comes back into the meeting, Charlotte, can you remind him? Yeah?
Yes, as soon as he attends, I'll get him to verbally make his declaration.
Thank you very much. So we can now get down to the business in hand. So, first of all, I'd like to welcome the opportunity to scrutinise this, and also, as I say, particularly grateful that Titarian officers have joined us. As committee will remember, this was originally included as part of a big agenda, and we thought it was so important we needed to take this separate meeting to look at it individually. So we appreciate that. And the other thing we wanted to appreciate was the fact that an easy read was attached. But Councillor Edwards, Carolyn has some comment to make on that. Carolyn, you're muted, Carolyn.
I didn't realise I was in so early on. Okay. Yeah, I just found the whole document really dense and very hard to read. And the easy read was exactly the same. As far as I could see with the easy read, it was the same document, only a bit shorter. I mean, you know, if we're finding it difficult to read, surely tenants or applicants are going to have difficulty in understanding it too. So, you know, I think an easy read means that the language has got to be much simpler. Thank you.
Before we go on to your presentation, officers, would anybody like to comment on that particular observation? I know that this is a legal document, but anybody? Claire, I can see you indicating.
Thank you. Yes, you're correct. It's a legal document, and I think us as officers also would prefer it to be in a much simpler language. So we are constrained to a certain extent by both its size and the language that is used. However, I do take on board the comment which Councillor Edwards has raised. And what I would like to propose is, following the completion of the final document, that actually we get together a group of tenants and applicants to have a look at what we can do to communicate that easier. That the main document will always need to remain the same in terms of the language and the legal jargon, but we can look to see if we can develop something with applicants and tenants to make that easier to read going forward.
Chair, you're on mute, sorry.
I think I'll just leave this on permanently. Thank you very much. I'm sure that will be most appreciated by everybody. I know you have a presentation to make, but I can see two people indicating. I'll just take those two indications and then we'll let you do your presentation before we go through questions. Councillor Suzanne Paddison.
Oh, thank you very much, Chair. It's just to answer your call. Does anybody else have comments to make? I totally concur with Councillor Edwards, and I will say that an easy read is always going to be sort of less legal. You know, you're not going to have an easy read that will stand up to legal sort of scrutiny. So by its very nature, you understand that as soon as you put one out, it's not going to be the sort of legal document that you submit. But for ease of use, why are you going to wait until after you've done this? Why can't you do it concurrently? Thank you.
It's a good question. Titarian, would you like to reply to that?
Yep, I'm happy to reply to that. The reason we're not going to do that, so we've got a summary document and an easy read within the pack, I believe, which was circulated. Because we're in a consultation process, obviously there may be elements and responses that we get from the public and yourselves indeed, which will lead to it being changed after. So my proposal to do it once the document is complete is so that we can have work with tenants. It may take a number of weeks to get people together, you know, at the right time and get it produced. So my proposal was to do it once we know what the final document is going to be.
Yeah, I can see the point of that. John Hodges, you indicated. You're on mute, John.
Yes, no longer. Yeah, thank you, Chair. Yes, I just wanted to explain. Members may recall that at one of your previous meetings, we looked at the charging policy, charging for social care and support, which we provided, and we greatly simplified that document to take out a lot of the procedural elements. The document at which you're looking is required by the Housing Act 1996, and that requires a scheme which not only sets out policy, but also how we determine priorities and the procedure to be followed. So whereas we were able to produce a simpler thing which set out the council's discretions in other situations, this one does require to be a fairly complete working document which shows not only what we intend to do, but the procedure which will be followed. So that's one of the other reasons why it is so lengthy, I'm afraid.
Thank you for that, John. I can see the officer indicating.
Yes, Chair, sorry. I can just see that Councillor Miller has just joined, so I don't know if you just want to deal with his declaration at this point.
Thank you very much for that. Welcome, John. Did you want to make your declaration of interest?
Yes, please, Chair. My declaration is that I got family members who rent from Titarian.
Thank you for that. Charlotte, you can send the necessary form out, yeah?
Yes,
Can I
Right.
apologise for being late, Chair? My system is playing up, so I may drop out at any time. Thank you.
Thank you for that. Don't worry about it. Right, okay, I think we've dealt with the preliminaries. So, Titarian, would you like to give us your presentation?
Yes, certainly. I'm hoping one of my council colleagues is going to share the presentation for us. We don't. Yes, on cue. Lovely. Well, thank you very much for inviting us along to the meeting this morning. It's really lovely to be able to see you all, albeit virtually. Unfortunately, we're still living in that world, aren't we? Okay, so without further ado, I'll make a start on the slides. So Gareth, would you mind moving on to the next slide, please? Thank you. Okay, just a bit of a background, and I don't want to dwell on this slide because I know lots of this was included in the pre-report that you had with a copy of the scheme. So just a reminder to everybody, really, and that's following housing stock transfer in 2011, the council retained its role as the local strategic housing authority. And in that role, the council has the legal responsibility to formulate, adopt and amend an allocation scheme and, where appropriate, consult on the proposed changes to it. So under the 2010 transfer agreement, Neath Talbot Council and then NPT Homes, now Titarian, set up a special relationship in terms of how that policy, that document, would be implemented. And that is where, as part of the shared lettings policy, Titarian, or NPT Homes as it was then, would take responsibility for the administration, the operational implementation of that policy. However, the policy document itself would remain a document in which we would work on together. We would review it together, we would monitor it together to make sure that it is operating as we wish. So this document that is before you today, that is the proposed new allocations policy, which is currently out for a 90-day public consultation exercise with a proposed closing date of the 6th of October 2021. If we could just move on to the next slide, please, Gareth. So the document itself was last reviewed in 2015, and it had a 2-year review period on it. So in 2017, Titarian and officers from the council, and that was a range of departments in which officers who were involved, from the housing options team to your environmental health department to your housing strategy colleagues. So we started reviewing that in 2017, and we thought fundamentally it needed a really good revisit. I guess in line with what Councillor Edwards has raised, the previous document was even more lengthy and included lots of other things in it. So we have made a particular effort this time to strip out anything which isn't needed, and hence that took a little bit longer. We also wanted to work individually with the different departments to make sure that what was included in that document wasn't causing any particular areas of concern for colleagues, but also it met the needs and demands which those departments had placed on them. So this document was a more comprehensive review. It was nearing completion at the start of 2020. However, we all know what happened at the start of 2020, and our priorities quite rightly focused on the people who were coming through homeless, and making sure that they were accommodated. So the project was paused, but now is being brought back to you because that has been completed. So if we could move on to the next slide, please. Okay, so one of the important areas for us to consider when looking at this document is those who are homeless. And I think it's important to emphasise that Titarian and the council work closely together in ensuring the needs of homelessness families are met. So Part 2 of the Housing Wales Act 2014 does place a duty on the council to take steps to help homeless households find suitable accommodation. And one of those ways in which they're able to meet that need is through the stock, which is now held by Titarian, as well as other partner RSLs such as Coastal and Pobl and Link. During the pandemic, we met as a group to make sure those needs of homelessness families were met. We've all got our own individual allocations policy, but I would like to assure you that we were all on the same page in terms of making sure this was about the people themselves and about making sure that they were housed. So Titarian is an active partner with the council, as I've said, in terms of alleviating homeless, but also preventing homelessness as well. And as well as the allocations policy, we have a number of other arrangements in place with yourselves in order to meet that need. So, for example, we lease properties to your housing options team in which that they can use as temporary accommodation. If we can move on to the next slide, please, Gareth. Okay, an important part for us to emphasise, and again, I don't want to dwell on this point because I know it was included within your report, and I know we want to have more time for some questions. But just to emphasise, the prioritisation of applicants under the banding system in the policy is not in any way affected by an applicant's gender, marital, civil partnership status, race, religion, belief, sex or sexual orientation. That has no bearing on how they complete bids and how they're treated and how we determine who gets a particular property. There is no known or anticipated negative impacts of an applicant's household by virtue of the protected characteristics of any household member. However, we will update the integrated impact assessment following further impact testing and any consultation responses that we receive, including any questions or observations which are made in today's meeting. If we could just move on to the next slide, Gareth, that'd be great. Right, at this point, I'm going to hand over to my colleague, Chris Edwards. Chris has been responsible for leading on some of the impact assessment testing, which we've done in order to test what we've written in the new policy. So he would like to give you a bit more information about that.
Okay, thank you, Claire. Good morning, all. I think one of the most important aspects of looking at any allocation policy, any allocation scheme, is the impact it has on the residents, and more particularly on the applicants who apply to us for rehousing. And if something is proposed to change that would have such a negative impact on our applicants, then it's something I don't think we'd wish to pursue. So the idea was to carry out a testing regime to make sure that wasn't the case. And if it was, then to look at alternative ways of dealing with it. But as you can see from some of our figures, then we carry out testing on 10% of cases, sometimes a bit more, depending on the lead need factor, to see whether or not it had a positive, negative, or no change impact on applicants who've got applications with us. So the idea was to look at each lead need factor in turn, and the policy assesses an application based on housing needs, but the lead need factor then determines what band somebody goes into. So, for example, as you can see from the table there, we looked at housing options cases, environmental health cases, people who suffer from overcrowding, acute overcrowding in some cases, health conditions, social conditions, and then any others like sharing facilities, for example. So they would be need factors. There's also a case where we have lots of applicants who have no housing need as determined by the policy, and they're able to go on a waiting list as well. So basically, doing the testing determined that there was no real material change to somebody's position on the list because of the changes proposed in the new policy. So, for example, if you look at some of this information that's on the screen there, we looked at overcrowded cases. So we assessed 10% of those cases to see what the material effect would be. And basically, there was no effect, there was no change, etc., to those cases. So it meant then that if somebody was on the waiting list now in 10th position, for example, they would remain in that position. Now, the good thing about it was where we determined there was a lead need factor that did change, then because the circumstances surrounding that case, then another lead need factor came into account. So, for example, if somebody had a lead need for social reasons and a certain band given for social, then there was something else underlying as well that would have affected their housing needs, and therefore their band remained the same. So one example was in terms of lack of amenities. It was an incorrect lead need in that case, but it resulted in the same band being awarded, in this case a silver band award, because there was another lead need factor. So basically, when you're looking at cases, you look at the whole circumstances of the case, and you determine then what the lead need factor is out of that. And from the testing, as I said, it proved to be the case that there was no material effect to our applicants in terms of being reduced then in the banding system, which means that opportunities for rehousing were not diminished in any way. So that was a good positive impact for us, because we didn't want to see then the negative effect of that happening. Okay, thank you, Gareth. Okay, so we asked our colleagues as well in our housing options team to look at housing options cases and to see whether or not then there would be any affected, because what we looked at in terms of the policy was a change then in terms of the urgent needs for being rehoused in terms of homelessness. So those cases where, for example, an applicant was in interim accommodation because they had nowhere to live, they had no roof, then those would be considered as urgent cases. Other cases then where, for example, somebody may be living with family who were given notice to leave by the family would be gold band cases. And then we brought in a silver band case as well with housing options to look at those cases where the duty had expired, for example, but there should still be some level of support. So basically, a test was done then on these cases, on 37 cases, to look at the impact they would have. And as you can see from that chart, 24% of these cases would be downgraded, mainly going from urgent to gold band. Now, that really is a positive negative, because these are the cases weren't in the current scheme as urgent as those cases, for example, in council interim accommodation. So these cases were considered alongside those cases, but really speaking, their level, unfortunately, of urgency wasn't as great as other cases. Now, looking at those cases, as you can see there, it counts for 24% of all tested. But it means really, in effect, that 24% of all cases then would have a similar impact on them. And looking at those cases individually, those cases really amounted to cases whereby, for example, they were mainly one-bedroom cases, which were not rehoused through the scheme, however, may have been in a position which now meant their position on the list then was a bit further down the line. But it didn't affect those applicants then with that urgent housing need. They would still be rehoused within, a very reasonable timescale. And even these cases which were downgraded, gone from urgent to gold, for example, would still have been rehoused within a reasonable period, because when you look at cases for rehousing, you have to look at the whole. So in that sense, you look at where they want to be rehoused, what type of accommodation, or what demand there is in that area. So I'll give you an example. Looking at one of the cases, they were a 1G urgent case. They were a person living with their parents. Now they would be reduced to gold case, which meant that originally they were 11th on the waiting list for a bid they made. Now they would have gone down 2 places. So they weren't rehoused anyway, but they would have gone down 2 places. Now, where they're looking for rehousing, there is a small number of 1-bedroom properties that we would own as a housing provider. So their chances then would be slightly diminished. However, those urgent cases wouldn't be affected because they're in interim accommodation, for example, or in temporary accommodation in one sense or another. So basically, that was similar pattern for all these cases, apart from a couple where, for example, they hadn't bid for accommodation. So the real question is, should they be in urgent, for example, in the first place? Because they haven't actually bid for accommodation. Another one had been rehoused by Pobble very recently. So you can see then that, you know, we're not obviously the only housing provider, and there are opportunities with other housing providers who may have more 1-bedroom stock, for example, in areas of choice. Okay, thank you, Gareth. And like I said, this is a slide now based on those figures originally around those lead need factors and what happened to cases. So of the 75 tested there, you can see there were 73 no changes because, as I mentioned, the lead need either stayed the same, or there could have been another lead need factor which affected the application depending on the circumstances. And of the 75 then, there were 2 positive impacts. In other words, the band went up as opposed to staying the same. So there's no negative impact across the board in respect of other lead need factors apart from those housing options cases where there was a positive negative, which really demonstrates then that the changes proposed then would not have a negative impact on our applicants, and in some cases would have that positive impact. So therefore, applicants wouldn't have a less opportunity of being rehoused within a reasonable timescale, obviously depending on vacancies, the number of properties we have in that area, where they want to go, and people bid in as well, the demand issues as well. Okay, thank you very much.
Thank you. I didn't want to interrupt your presentation, but I know that Councillor Edwards does need to declare an interest, and I didn't want to let it go much longer. So, Councillor Edwards, can you declare your interest?
Yes, thank you, Chair. My apologies. It only just dawned on me that I may or may not have relatives living in Titarian. Could be Pobble, it could be something else, but I would prefer to declare an interest at this stage before the discussion starts. Thank you. Apologies again.
That's okay, no problem. Thank you very much for that. So, Charlotte, have you noted that? Yes?
Yes, and I'll circulate a declaration form.
Brilliant. So, Titarian, sorry to have interrupted you in the middle of that. Are we coming to the end of our presentation? Where are we up to? Sorry, I can't hear you. You're muted. Don't worry.
I'm double muted. It's my party trick. We've come to the end of the presentation now, so we're happy to take questions. I know we've received questions in advance from 2 members, so I don't know how you want to do it, whether you want to ask the questions to us or whether you just want us to answer those.
No, believe it or not, we do have a plan. But before we go into the plan, we had an hour's most interesting pre-briefing where basically we discussed a lot of things, but most importantly, we put the questions into categories so that councillors weren't asking ad hoc questions at different places. At least we think we've got a plan. Can I just say one thing about the presentation? It was very interesting. I wonder, however, having the presentation now, when we've already dealt with this big document, has actually confused us a little, because So, yeah, I can see a lot of people nodding because a lot of the questions that we want to ask may have been answered, but because we didn't have the presentation in advance to look at it, please forgive us if we're asking a question about something which you have just answered. We are doing our best here as non-experts in this field. Right, okay, now we are ready for the questions. So I'll start off. On page 13, you're talking about a standard occupational contract versus a secure occupational contract, and we just wondered what the difference was.
Okay, I think my colleague Chris is probably best placed to answer that one.
Yes, of course. Okay, so at the moment, then we operate on a two-tenancy agreement basis. The two tenancies we operate on are assured short-hold tenancies or assured tenancies, full rights, what's called full rights tenancies. Sorry, I mentioned three. There's two in terms of assured. There's an assured short-hold tenancy. So if somebody comes into us as a new tenant who's not been a previous tenant elsewhere, for example, or on a transfer case, then they would be awarded an assured short-hold tenancy. Yeah, a bit like the introductory tenancies that the council used to operate before, where, for example, somebody has to demonstrate their ability to manage their tenancy for the first year of that tenancy, and then they would become an assured tenant. The assured tenancy regime is based on two tenancy types, the assured full rights tenancy and the assured protected rights tenancy. So we're a bit unique like other stock transfer organisations in that we had tenants then who were obviously long-standing tenants, secure tenants with the council. So they came into our assured protected rights regime. So they retained this certain rights. Anybody comes in after then the stock transfer date, March 2011, then would become either assured short-hold tenants or assured full rights tenants. And if you're assured short-hold tenant, after a year you become an assured full rights tenant unless there are issues regarding a tenancy. So that's a basic premise around it. In terms of contracts, under the Renting Homes Act, which is due for consideration next year, then there'll be two contracts. So the Welsh Government said, now you have contracts which are going to be standardised across the sector, and there'll be a standard contract and a secure contract. The standard contract becomes, in effect, your assured short-hold tenancy. So it replaces that. The secure contract replaces your assured full rights, assured protected rights tenancies. So that's the basic principle, basically. I hope that answers it.
Yeah, thank you very much for that. I think I understand that. Sonia, did you want to come in specifically about this point before we go to our next question?
I did, thank you, Chair. Yeah, it was as a part of your answer, Chris, you indicated that tenants that had been in prior to the stock transfer had retained some rights. Is there anywhere that we could have what those rights they've retained are available?
Yes, of course, we should be able to provide that. With the caveat that one right has now diminished, which you're probably aware the right to buy has been stopped. So that was one of the rights then they retained then as a protected rights tenant. But yeah, of course, no problem. Would you like to see the difference between assured short-hold and full rights and protected rights tenants?
Yes, I think as a committee we would like to see that. If you could send it through to the Democratic officer, she'll make sure we see the answers to that. Thank you for that question, Sonia. That was excellent. Thank you. Right, Arwin, you have a question about succession. Councillor Woolcock.
Thank you, Chair. I understand that, and thank you for your indulgence as well in sending me the new page numbers. They are slightly different to the original document that was sent out. And Claire, Chris, nice to see you again, albeit on screen in front of a laptop.
You too.
I think it's the first time I've seen you actually since the stock was transferred. So it's lovely to see you both again. Yeah, okay. Succession planning. Let me just call up my the email. I think you may have had these as well, haven't you?
Yes, we have.
It's now then on page 39, paragraph 7.8. And my question is, in the event of a request for succession of tenancy, and that right has already been exercised, in brackets, up to the maximum permitted number, if the person making the request needs to live in the area in order to receive family support, will Tai Tarian consider the request for succession? Now, the reason I ask that is that I have had an experience of a person needing to be moved because the home that he occupied was under-occupied. But I'm pleased to say that he was rehoused in a flat adjacent actually to his property, which allowed him then to remain locally to receive that family support. So that is the question. Thank you, Chair.
Anybody want to take that?
Yeah, Chris and I also met beforehand and looked at the question, so Chris is going to answer this one.
Yes, thank you. Yeah, nice to see you as well, Councillor Wilcock. It's been a long time. Right, okay. The issue around succession is quite a very emotive subject. As you can all appreciate, I'm sure you've come across cases in the past where you've been involved in them heavily. Just a brief explanation around successions, if I may, just for everybody's benefit. I'm sure you're also aware of this, but there are three levels that we look at in terms of succession. There is what is called an automatic right of succession, which befalls then partners, for example, of the person who's deceased. There is a second level which looks at family members. So a family member may be a son or daughter, for example, who's been living with that person 12 months before they passed away, then would be entitled to succeed to that tenancy. Now, in saying they succeed to that tenancy, which is right, they would get a tenancy with us, it doesn't automatically follow they would succeed to that property. Because it could be issues of under occupation, as you mentioned previously, Councillor Wilcock. There could be issues of affordability, etc. We have to consider then in determining whether or not they're allowed to remain at that property or moved on elsewhere. The third level is in respect of a family member, for example, who may have lived with that person for less than 12 months before they passed away. And all these issues do consider then the level of succession. Previously, have there been one or more successions in the past? But in terms of automatic succession rights, then that would follow in terms of partners, etc. We look at circumstances around the other factors. So say, for example, now you had a resident then who applied for succession, but they haven't lived there for 12 months. All the factors we look at, the circumstances around that case, then would determine how we progress with that case. And there could be issues then we take into consideration because they are very sensitive issues that may result in that person staying there because that's the best thing to do for that person. So we always look at the right thing to do, and the right thing to do in our eyes is to look at the individual circumstances and how best placed they are to live at that accommodation and for the life of that tenancy. Does it mean that somebody suffers from issues regarding affordability? Are there sensitive medical issues we need to consider? And we always consider all the factors before looking at making a decision on any of these cases. So invariably, we will not make anybody homeless if we can help it. So we will always look to help somebody out because that's the last thing we want is to make somebody homeless because of an event that's occurred in their lives that has resulted in this position they're in. So we always look at the individual circumstances. We always very supportive for people, and I've got a couple of cases recently where we've looked at, and there are cases where these family members then haven't lived there for 12 months. But when you look at the circumstances surrounding that case, you wouldn't do anything else apart from support their request because the alternative would be so detrimental to that person. So we have to consider all factors. We consider demand issues as well, because you couldn't really justify leaving a single person in a 3-bedroom house, for example, where there's a huge demand from families for that type of accommodation. If there's nothing underlying that would result in something, going wrong, then So we look at all the factors and we consider every case individually, but it is individual circumstances we look at in terms of succession, apart from those that are automatic, for example. I hope that goes a way to explain it.
We would also look to make sure that if someone, in that case, I think that you mentioned, Councillor Wilcock, around needing to be near support networks. If it comes to a position where we are asking someone to move, for example, out of a 3-bedroom house because they're a single person, we will always work with them to move to a property within the locality where they need to be, and as far as possible. Where we've got stock, we've also in the past worked with other housing associations if they've got more stock than we have in order to move that person to an appropriate property, and we wouldn't make them homeless in the interim as long as that person's request was reasonable and that actually we know that there's a chance of a property becoming available. It's just a case of time for that to become available.
Thank you for that. Right, Councillor John Miller, you had a question about policy.
Yes, thank you, Chair. The question I'm relating to is on page 16, and it's paragraph 2.8. Okay, the paragraph reads, nothing contained in this policy shall prevent the Council and Titarian from developing and agreeing a local lettings policy to meet the specific local issues. And where relevant, these local lettings procedures shall apply in addition or instead of provisions in this policy. Now, do we have a policy relating to that section? In other words, have we got a separate policy on top of this policy that we're scrutinising today?
There is no. Sorry, Chair, do you want me to answer that one?
Yes, please. Yes.
There is no local lettings policies at the moment. When we look to introduce a local lettings policy, as I say, we do that in conjunction with the council. That isn't a case that either the council or either Titarian can just go away and come up with a policy and start implementing it. If we come up with a local lettings policy, it's because there is a need to come up with that local lettings policy. And I believe the last local lettings policy we did have in place relating to Bush Row did indeed come to local members in order to consider that. So at the current time, there are no local lettings policies being presented for you to consider. When they are introduced, they tend to be time-bound because they're introduced to overcome a particular issue which might be being experienced at that current time. So just for an example, we did have a particular issue in one of our blocks of flats in Bush Row in the Melon, going back a couple of years ago, where there was a concern around drug dealing and drug taking within that particular block. Now, one of the things that we looked to do at that time was looked to ensure that no one else being accommodated in that block had a history of any drug abuse or drug taking, and that was in an effort to turn the block around and actually make it a nice place to live, as opposed to a place where people, you know, really didn't want to live and felt very frightened to live there. So that would be an example where we would introduce a local lettings policy, but we currently haven't got any local lettings policies which we're presenting to yourselves this morning in order to consider. Are
you happy with that, John?
Yes, thank you very much, Chair.
Yeah, thank you for that clarification. Yeah, and the case study was interesting as well. Councillor Edwards, I have made notes to myself in the pre-briefing, but next to this it just says Carolyn urgent, and I haven't the slightest idea what the question was.
Yeah, I can't give you the page number because I lost it somewhere along the line, but it was section 9, paragraph 3, and it states that urgent reviews will take place within 3 months. Now, to me, urgent is like yesterday, not 3 months. So what is the time scale on those? Thank you.
Yes, we would agree with you on that. If someone is placed in an urgent band, we would expect them to be housed fairly quickly. They're right at the top of the list. They've got every opportunity in order to bid for property. And the only person who is going to, I guess, pip them to the post is someone else who's also in an urgent band, who has been in that band for longer, who has been waiting longer. What we sometimes find is that people in an urgent band don't bid as we would expect. So some of them won't be actively bidding. They sit there with an urgent status, and then 3 months down the line they haven't bid for anything. So the intention of that particular paragraph is for us to be able to review to make sure that somebody is actively bidding. And what we will do is look to see what properties we've had come available in the last 3 months. So if, for example, they're a case who are waiting for a specific property, it might be an adapted property, and we haven't actually had any adapted properties come available in that time, that's fine. Obviously it might take a little bit longer for a specific type of property. However, if they're just somebody who's waiting for a general needs 3-bed property in an area where we've had 2-3 properties come available within that 3-month period and they've decided not to bid for them, then we will review it and actually question whether they need to be in an urgent status band. Our other reason for reviewing it is because people who are in an urgent housing need, they should move on very quickly, and they will be registered for housing, not only with Titarium, but they'll be registered with Pobble and Coastal, for example. And what we need to make sure of is if they've been accommodated or housed somewhere else, they might even have got a property, secured property in the private sector. We need to make sure that their application is removed from our housing register. We may not have known that they've gone on and had this other accommodation, yet they're sat on the list still with an urgent housing need. So it's just about making sure that the register is up to date and that someone is getting as much support as they can, because actually, yes, if someone's in an urgent housing need, we would expect them to be housed also within that time frame.
Thank you, Chair. Yeah, that's good. Yeah, thank you.
With that.
Yes.
Councillor Paterson, Suzanne, I think you wanted to ask something about GDPR and the forms.
Yes, I just wanted to thank you very much for your presentation this morning. And I have to extend a little bit of sympathy with Titarium in general, in that you're now down to considering who's the most urgent out of the urgent ones, and I totally take that on board, and that's just a sign of the times we're in. But I just thought I'd like to say that. But then with regards to GDPR, we do find it increasingly difficult then when we're sent encrypted messages and our forms are not sufficient for your forms. We have a legal department and we understand your legalities as well. But sometimes it does feel as if it's a bit of a barrier rather than a help. And I wondered if you could just try and streamline it a bit. I totally get where you're coming from, but it seems to us as if there's a bit of barrier. Yeah, thank you.
Okay. Do you want me to answer?
Yes, please.
Yeah. We would hate for you to be able to see that as a barrier, because we genuinely do want to work in partnership with all council officers, yourselves, and officers who are employed by the council. Yes, our forms have been drawn up with legal advice, and that is what we need. However, having listened to your explanation there, I think probably what I can offer is I can speak to our corporate services department, who are responsible for overseeing our and making sure we're compliant in terms of GDPR. And if you let me know who's the most appropriate person within the council for them to speak to, let's see if we can perhaps come to a middle ground in terms of something which is acceptable, so we haven't got loads and loads of different forms flying around. And do you know what? If it is that we can't and we do need these separate forms, at least we're both of a position of understanding why we need those separate forms. So if following the meeting, if Rob or Gareth or Angela would like to let me know who's the best person for them to contact, let's see if we can come up with a better system or explanation.
Excellent, Chair. Thank you.
Thank you for that. Before I bring John Hodges in, because John was not in the pre-briefing, but Craig Griffiths, our legal officer, was in the pre-briefing. Craig is going to write to Titarian on behalf of the committee to ask that question. So that might prevent John from having to speak because Craig's already onto it. John, did you still have anything to say?
Yes, Chair, I can. Just to help the committee, we in the council have had to amend various of our forms because I suppose the simple big thing which GDPR brought in and the Data Protection Act from 2018 was that consent to sharing of information had to be a lot more specific. So whereas in the past we'd had a simple form saying, I consent to you sharing my information, that isn't really sufficient. And I suspect the issue has been that Titarian have updated their documentation and policies to reflect the fact that somebody has to understand what is they're agreeing to share and what purposes it's going to be used for. And we may have some forms still within the council which don't give that level of detail, but I'm sure it's going to be easily resolved. But equally, I know from other areas, particularly parents who give consent for information concerning themselves and their children, we have had to update those forms to reflect the requirements of the law.
Thank you for that, John. So we'll leave that to the legal guys to talk to each other in both organisations. Right, on page 20, 431, it says the applicants will be required to register interest using the Titarian website. And we were just wondering, how do they apply if they're not computer literate?
Sorry, I'm just looking for the relevant section.
Sorry, you want me to repeat it? Are you okay?
No, is it 4.3.1?
That's it. Brilliant.
Yep. Yeah. Okay, so we have also got a team of people working within Titarian. Like most organisations, both public and private and voluntary, lots of our processes do rely on digital skills in order to access them. But we do have a team of people. What we tend to find is lots of people, when we've spoken with them, so lots of them may, for example, have had to make claims for benefits, for example. All of that would have needed to have been done online. There will be fewer exceptions to that as we go on. But if someone isn't able to make that application, we will take that from them over the telephone.
Thank you. That's the simple answer that we wanted, I think. I can see Chris Edwards indicating.
Yes, sorry, Chair, just to add on to what Claire said, we also are aware of a number of applicants who do not have any digital skills. You know, my mother would be able to do it herself, you know. So where we've got that, then our team would step in and they would help that person throughout the course of their application. So, for example, they would contact that person when there's a property that may be available for them and they would submit a bid on their behalf. So they will go through things on a weekly basis, for example, with them. So it's important for us to be aware and be fully conversant with the fact that some people cannot access the internet, wouldn't know how to use it. Lots of people have family help, but we would always step in and help where we identify somebody who somebody tells us they cannot access any internet facility. So we would do that on a regular basis, on a weekly basis then.
Thank you for that. Thinking ahead to the end of this and the whole purpose of why we are here, which is mainly that we make comments and that you observe those comments and possibly include it in the draft policy. Is it clear in the draft policy that that assistance is available?
We mention about the placing of bids, helping people to place bids, but not at this initial stage. So yeah, we could include something in that particular part.
I think we'd all be happy if, particularly in the in the easy read as well, it's made clear that if you're not good, help is there. Excellent. Suzanne, I can see you indicating Councillor Paddison.
Yeah, it was just on that very point, Chair. Yes, it may account for why people of urgent clarification may not be bidding. So I just wondered if that, you know, if you do give that advice, whether that is maybe the reason why they're urgent, but they're not bidding. Maybe they just don't know how.
Yeah, I think that's a very valid point. Yeah, okay, Claire? Do you want to
Yes,
come back
that's
to that?
fine. We'll take that. I was going to say we do support people through, but you're absolutely right. Yes, there could be someone who's not bid for that reason. So we'll look to include that.
Right, excellent. Okay, we're on page 21. And this is something that jumped out at me when we first saw this report and when we considered bringing it back to a special meeting. On page 21, you've got 4.3.6 and 4.3.7. Now, 4.3.6 says that the applicant may wish to have correspondence sent to a different address. And I'm understanding and interpreting that myself as possibly somebody who wishes to leave the family home, perhaps to escape domestic abuse or whatever. But then 4.3.7 says, at any stage, Titarian may undertake a visit to the applicant's current place of residence. Now, not being an expert on this, I just suddenly saw a nightmare scenario where somebody was applying to leave the home and then a Titarian officer turned up and said, we want to discuss your application. So can you just clarify that for me?
Yeah, certainly. It was a point actually when I was rereading it yesterday that I noted, and actually it's arranged in advance. It is an arranged in advance appointment as opposed to a cold call, shall we say, at someone's property. What I would say is sometimes we use those visits. So for just to give you a bit of a case study, if someone's living in a private rented property and they're struggling to get their landlord, perhaps they don't want to tell their landlord they're looking to move on, but that condition's in a particularly poor state. It wouldn't qualify for environmental health to become involved. But what we might do is arrange for that person to visit that property to be able to see it, and that sometimes overcomes the need for us to get to for a landlord's reference from a private landlord. So we don't carry out a great number of visits, but what I will include in there is that it's a pre-arranged visit. So that the scenario you mentioned wouldn't occur. Thank you.
Excellent. We're beginning, I think, to make some really valid points here. We've got quite a few more to go, mind you. Excellent. So let's carry on. Suzanne, you wanted to ask something about 4.8.1 on page 25, followed by myself if it's not all covered.
Thank you very much, Chair. Yeah, 4.8.1, just a second. Oh, dear me.
Page 25.
Thank you very much. Yeah, and it was about not deliberately overcrowding somewhere as a reason. You know, you don't want people to make a deliberate overcrowding situation to make people come further up the list. But my question is, how do you assess sort of like if you've got middle-aged parents with grown-up children who suddenly have a need, you know, through divorce or maybe, I don't know, whatever the need is, saying, okay, you can come here for a while, even if the house may not be that suitable. Is it straight, no, you can't come because that would make it overcrowding? Or is it that there's some other accommodation that can be made? That's basically my question. Thank you.
Claire, do you want to take that?
I might defer this one to my colleague Chris, who I think will have lots of examples of this scenario from implementing the policy.
I was anticipating that, to be honest with you. Well, unfortunately, we have a few applicants who, in the past, who have not been, who've been a bit economical with the truth, shall we say. However, most people then don't do something deliberately. There's always something behind it that happens in their family circumstances, which means something like that happens. For example, somebody moves in with somebody because of a relationship breakdown, and that happens quite often. Now, if that did happen to somebody, then we'd look at the circumstances, and that wouldn't be deliberate. That wouldn't be a deliberate attempt then to get higher on the housing banding scheme, for example, because there's legitimate reasons behind it. So absolutely not. But we look at the circumstances, and to be honest, I think I've only come across one or two where we've said, I'm sorry, we're not going to give you a higher band because you shouldn't have done that. You know, you did that, you know, knowingly, you know, to try and get an advantage, but it doesn't happen very often.
Thank you, Chair.
You know, so.
Thank you for that. So there's a degree of flexibility in interpretation there. My question was on the same point, 4.8.1. It says the applicant must not give up affordable, suitable private rented accommodation which they are able to maintain. And I just wondered how that was assessed. Which they are able to maintain in particular. How do we know that? How do you know that?
Well, if necessary, as Claire mentioned, we will carry out a visit to a property, but if they've already given it up, then we'd look at the circumstances around why they've given that property up and moved elsewhere. We discuss it with other agencies. For example, we discuss it with Environmental Health to see if they're aware of that person. We have access to the Rent Smart Wales scheme as well, so we have access to that. So we do those checks firstly. If there's something then we're not sure about, we always have the ability to put an application on hold, for example, while we carry out further investigative checks. But, you know, for the most part, then we find that people don't give up accommodation they would reasonably be able to maintain, and unless there was something underlying. So once we've done our investigations, then we determine whether or not then there is a deliberate, you know, move to do something. But as I said before, it happens very, very rarely. Once we've done all the checks, there's always circumstances that allow for it.
Okay, thank you for that. Right, okay. Arwin, Councillor Woolcock, you had some questions about under 16s.
Thank you, Chair. Yeah, bear with me just to find the email again. Again, I think, Chris and Claire, you received this in advance, haven't you?
Yes, we've had this one. That's correct.
Yeah, if I, for the benefit of the other members, then Claire, if I could just read out the question I submitted, but that'll help the discussion then. It refers to the two applications received from persons under the age of 16. And my question is, would Titarian make any background checks with children's services in addition to internal measures of being, and I quote, satisfied that they have the sufficient capacity to understand the rights and obligations required of them to occupy a property let by Titarian? It's vulnerability really that I'm referring to here, Claire. Yeah, thank you.
Yeah, absolutely. I mean, 16-year-olds, well, all vulnerabilities really. Our aim is to set people up to succeed, not set them up to fail. Therefore, we will ask all the necessary questions beforehand around who are the agencies or organisations or departments within the local authority with whom they work with. And then we will work with those agencies, because, for example, it might be Dowis, for example, who also work with children's services who are supporting that individual. And we will make sure prior to allocating that tenancy or tenancy held in trust, that actually that person is going to have everything that they need in order to succeed. What we noticed going back about a year ago, and I will talk quickly because I know you've got lots of questions, was actually there was a gap for accommodation for people who were between the ages of 16 and 24 who'd never held a tenancy before. So aside from this lettings policy, we actually set up a designated 8-unit scheme with Dowis for people who fell within that age group, so that they would move in temporarily, gain the skills that they need in order to manage a tenancy independently before moving on. And children's services and other council departments are involved in the allocation of those 8 units that we've got. You happy with that, Arwin? Yeah?
Yes, Chair, thank you. Again, for the benefit of other members, there has been a change in the page numbers. It's paragraph 5.1.5, or no, sorry, 4.2.3 on page 19. Get it right in a minute.
Thank you.
I'm sorry, Chair. Can they just elaborate on that a bit as well? Sorry, just for your benefit. A few years ago, we had a case actually where a person was under 16 years of age. It happened in Councillor Richards' ward in Baglan, and unfortunately this lady's mother has passed away, so it left a 14-year-old in the property. So we worked with children's services then to make sure then that we got somebody then who would be able to sign a deed of trust, for example, and live with this the 14-year-old until she attained an age she would be able to be granted a tenancy in her own right. So we would always work with the agencies involved, especially with children's services, to make sure it's the right thing for somebody. Because as Claire mentioned, we don't set people up to fail. We want people to live in our accommodation for however long they wish to.
Thank you for that. And that case study is interesting. Are you happy with that, Arwin?
Yes, very happy with that, Chair. I'm pleased with the response. Thank you.
You also had a question about benefits.
I did, Chair. Yeah, this is on page 30, and this is paragraph 5.1.5. And again, Chris, Claire, you will have received this, but for the benefit of the other members, I'll read this out again. It makes reference to financial assessments. Now, as Neath for Talbot County Borough Council has ultimate responsibility for awarding or administering benefits, for example, housing benefit, council tax benefit, spare room subsidy, etc., will Titarian undertake these assessments in full consultation with NPT's Benefits Department? Thank you, Chair.
Claire?
Okay, yep, I'll take that one. Yes, absolutely. We've invested, and so have your colleagues, a lot of time in building up that partnership working arrangements. As Titarian, we do employ a team of financial inclusion officers. In fact, some of them to be transferred over from the council, from the Welfare Rights Unit back in 2011. So we carry out the assessments in-house. However, we do work with your colleagues in the council to make sure when we are undertaking those assessments, we are fully aware of all the regulations that govern whether someone's entitled to benefits, and we support them in terms of providing or making sure they provide that additional information which your colleagues, for example, in the Housing Benefit Department may need in order to make that assessment for that claim for housing benefits. So we'll chase that up with our tenants to make sure they receive that in a timely manner. One of the other things to mention is that quite often a move to a new property triggers a claim for universal credit, which would take them outside of, for example, the housing benefit regime. They will actually receive universal credit housing element for that. So one of the other partnerships which we've built up locally is with the local job centres and with DWP in order to make sure that those tenants also have the same, and those applicants have the same support and experience.
You happy with that? Yeah?
Thank you, Chair.
Thank you. Right, now we come to a collection of questions. I suspect some of these might have been covered in your presentation, but as I said, we've had pages and pages of the document to read and then the presentation, and our minds might be slightly boggling, so please forgive us.
That's fine.
So, Suzanne, you had a question about veterans.
Thank you, Chair. Thank you very much. Yes. My question was about the veterans policy, and in the pre-brief I was given some information by one of my colleagues. And my question now is, if under the veterans policy, do they absolutely have to have a prior link with this area? Because when veterans are sort of, I think demobbed is the only thing I can think of. They may not be in the area that they originated from. So is it an absolute that they have to have links with the area prior to going into military service? Thank you.
I will defer this one to Chris, but I can't find that section in the policy, but I do recall reading it. And if they are living in an area, so say their last base was here, for example, they may have established a local connection through that route as opposed to where they had originated from when they first went into one of the forces. But I will defer that to Chris because operationally, Chris has more knowledge of the
I don't think policy. We have any bases in and around Neath Port Talbot, so they wouldn't have any links from being in a base, would they? We haven't got any.
But they may. No, but they may have based themselves here, for example. They may have, for example, so they may have been living in the area at the time that their contract comes to an end, or they decide to leave. I wonder if Chris has got any case studies of where that perhaps has happened.
I think that we've had occasion in the past where we've had some applications come through from ex-service personnel usually through the housing options route. Now, the local connection rules previously were based around the homelessness legislation, but of course now that's changed slightly. So if somebody applies to a, say for instance, coming out of the army, and they are on discharge, they know where to go. They apply then through the housing options route, and they will be supported as such. So, which gives them access then to the higher bands. Because ordinarily, if somebody applied from outside the county borough, had no connection with the county borough, then they wouldn't be eligible unless there were circumstances which assume they would be for higher band levels.
Right.
So,
Okay.
for example, if I was living, they normally come through that route, and then they're supported through that route. And that's the thing with the lead need factors. There's so many of them, but obviously the urgent ones being your housing options cases, etc. You see your health and social cases as well. So we could support it then if there's a particular reason for doing so, but usually through the housing options route. That's what happens.
Thank you, Chair. Thanks.
Like that.
Thank you. I've got a queue now, but if Sonia will forgive me, I'd like just to bring in Councillor Griffiths because of his experience in this, and then go back to Sonia. Councillor Griffiths.
Thank you, Chair. Following on your answers about the criteria of ex-service personnel having a link, you really haven't drilled down into it. What about if the link by the ex-service personnel, the actual person didn't have a link, but what about if the spouse had been born and bred in the borough? Would that count as a link? Because whenever the service personnel, man or woman, marries somebody from Neath for Talbot, as far as I'm concerned, that's a strong link. Thank you, Chair.
Thanks. Does anyone to answer that?
Absolutely. I'm just looking who's going to get to the local lettings bit first, whether it's me or Chris. Have you found that section, Chris? Because it certainly does refer to household members or indeed family that live in the local area as well. Have you got that section, Chris?
It does. The local connection rules allow service personnel, and I served overseas, for example, but my family lived in this area, then that's a local connection. So a spouse would absolutely be that local connection, which would allow that person an opportunity to go to higher bands depending on their circumstances. Yes, 100% support that.
Thank you for that clarification. Sonia, you've been very patient. Councillor Reynolds.
Thank you, Chair. As I indicated briefly, but fairly confusedly beforehand in the pre-brief, I had a question that I felt might follow on from Arwen's. So I'm going to take you back to 5.1.5, and it's that section rather than another, because I couldn't find, having I'm sure read it somewhere, there is a bit in this that talks about allocation and assessing financial, affordability financially. And I just wanted to ask whether the issues of service charges, which in some properties can be quite high, were also taken into account in terms of affordability for the applicant. And I ask this because I've had some residents who've moved in and then, because of a need, and then ended up moving back out again because the service charge was somewhat too much. So I wondered if you could help with that, please.
Yes, there's a couple of points to say on that, and I'm going really slowly on the screen, so I don't know if if I'm coming through very clearly. So I'll carry on speaking in the hope that I am.
You're fine.
Great. There's two elements to that. So firstly, yes, we take into account the cost of the whole property, the rent and the service charges. What generally happens when it comes to affordability, it tends to be those going for a 2-bed property and actually they're only eligible for a 1-bed property. That's where the big affordability issues come in. That's not to say that it doesn't happen when they are going for a property of the correct size. But yes, we look at affordability. One of the other things to add is we are actually undertaking a review of all of our service charges. So as part of the rent increase process, and we're working really closely with the Welsh Government and Community Housing Cymru, I'm not sure if you've all heard of those, in terms of reviewing how much those service charges are. And that's happening across Wales as a whole, because it is recognised that sometimes service charges can impact upon affordability.
If I may, Chair.
Yes, sure.
Yeah, just to say, is there any way that we can input to that review at all?
Yeah, absolutely. Tenants and applicants are going to be involved in that review as well, and we'd welcome your involvement in that.
Thank you.
Thank you very much for that. Councillor John Miller, I have made notes about your questions, but it actually next to John it says unreasonable. I'm sure you're not unreasonable, John, but it must have been a question, something to do with that. Thank you.
I think Councillor Peter Richards might argue against that, Chair. Yeah, my question is on page 37, and it's on section 7.1.2, although it may refer to other sections as well. It's where there's an unreasonable refusal.
Right.
I think that what I'm trying to get at here, Chair, is that what mechanism have you got in this policy for any challenges? For instance, an officer may think that it's an unreasonable refusal, whereas the applicant might think that it's a reasonable refusal. So how would you deal with that complication?
Yep. Chris, do you want to answer that one?
Yes, of course. Yes, of course. Yeah, well, basically, Councillor Miller, in terms of the policy, then anybody has a right to request a review of any decision made regarding their housing application. And that would extend to somebody who, for example, has been offered accommodation but has refused it, and then their application has been subsequently deferred for a period because the refusal was deemed to be unreasonable in that sense. So they can ask for a review request, which would be considered by then somebody who would be senior to whoever made the decision in the first place. And we'd look at all the grounds for the appeal request and consider all the circumstances at all times. But, you know, bids, for example, offers accommodation don't generally get refused. Only small numbers get refused, and of those numbers, even less than are considered to be unreasonable refusals. Most people have reasons for it, you know.
John, I can see you want to come back on that.
Yes, please, Chair. Is that written down in the policy anywhere, or is a separate appeals policy?
It is included in the
review policy. Sorry.
Yep. I read that section yesterday again, so I know it's definitely in there in terms of it being reviewed by someone who is more senior to the person making the original decision. I can't put my finger on exactly where in the policy it is, but it's definitely in there. And I've also located the whole section on local connection, which is on page 91 for information.
Thank you. Just coming back to John's question, and this is why any member of the committee, if anything occurs to you as a result of what one of the Titarian officers says, please do come in. I'm thinking about this appeal. So somebody's had an application that's been refused, and it's then looked at again by a more senior officer in Titarian. The person who's appealing, do they have any right to have an advocate with them to put their case if they're just completely bowled over by the whole process? Claire, I can see you nodding.
Yes, indeed, and I can assure you that's happened in the past. So we've had, they can either have a verbal review, as in they can, well, before the pandemic, they'd come along, we'd meet in the office and we would discuss it. And in those circumstances, the ones which I was involved in, the majority of them did bring an advocate with them. And that advocate might be a support worker, it might have been a family member. So yeah, absolutely. It's about getting to understand, isn't it, what the issues are and how we can work together so everybody understands what's happening and reach the right decision. The other way in which someone can have a review is in writing. So they might just want to write to us and say, look, will you review this decision again? I don't think it's right because of X, Y, and Z. So we really do try and accommodate whatever works for that individual, because we recognise unless you're used to coming to meetings and unless you're used to speaking to people in this kind of format, it is difficult for people to put across their views.
Thank you. And you know where this is leading to now, and I can see Chris and John wanting to come in. Is it made clear in the draft lettings policy that if you want it reviewed, you can have an advocate to help you?
Chair, can I leap in and tell you yes? Section 9 Section 9 makes it very clear. It sets it all out about. It makes it clear that there's it's the choice of the applicant if they want to ask to have an oral review rather than just on papers. And in 9.2.1, they'll be informed of their right to be heard, be accompanied, and to be represented by another person, whether they're qualified or not. So it is all made very clear that there's a proper procedure, they can be fully supported, and they have the choice about whether they simply ask for a review on the papers or have an oral hearing.
Thank you very much for that, John. Thanks. Chris, you're still indicating. Did you want to come in? Or is it a legacy hand?
Yes, thank you, Chair. John's correct. And Appendix 9, page 84 of the bundle, then the whole section on reviews and explains everything. So, thank you.
Right. Councillor John Miller, you were waving at me. Did you want to come in? You don't want to come in. Okay, right. Where am I up to? Sonia, 7, 10, 11, you wanted to ask something about disability. Councillor Reynolds.
Thank you, Chair. Yes, I had a couple of questions on this area. I wanted to know find my bit. 7.10.11 or 7.10.10 says about the allocation of adapted properties, and there's an indication that if there's no one with a disability available for that property, it may be allocated elsewhere. My concern, as you'll understand, is for the stock of adapted properties. So I wanted to know whether there's anything in place to preserve the adaptations, despite the fact the property being used for other needs, or whether it is likely that they may be, de-adapted, as it were, if that's a way of saying, or how that may go forward, and whether or not there's any way that we could make sure that there are adapted properties available when the need is there. Thank you.
Thank you for that.
And I'll come back to my second question.
Yeah, that's best. Anybody like to answer about the adapted properties?
Yes, I think this is probably going to be a bit of a double act. Teresa, on cue. Go on then, Chris, you go first.
Yeah, I was just going to say, Councillor Reynolds, wherever possible, then we will always allocate adapted accommodation to somebody who needs those adaptations. So it's a twofold system in play at the moment, and you have to understand, obviously, firstly, that level of adaptations does vary quite significantly from property to property. Sometimes we have properties that are what we class as fully adapted, in that they're suitable for a wheelchair user, for example. Other properties may have had partial adaptations, like a walk-in shower, a stair lift, for example, level access, those sorts of things. Now, there's a twofold system of looking at it. First of all, we'd look outside the scheme. So we try and match an applicant to a property. So we look at our database of applicants, and wherever possible, then we'll match that applicant to that property. So say, for example, a 3-bedroom property came up in Soundfield that was fully adapted. we'd look at our waiting list, a disabled waiting list then, for anybody needs those adaptations and match the two together. What happens sometimes is that we come across properties that might have been partially adapted, where we tried that and it hasn't worked because we can't find anybody for it. What happens then is we will allocate the property through the Homes by Choice scheme, so we'll advertise it, but we'll always advertise it as suitable for disabled applicants first. So, for example, if we had a 3-bedroom property with a stair lift, walk-in shower, we didn't find anybody for it, we'd allocate it through Homes by Choice and advertise it as such that we'd say 3-bedroom disabled applicants first, then we'd go down to 2-bedroom disabled applicants, and then finally you would go to general needs applicants if we could never let it like that. Now, we can reuse and recirculate equipment, like, for example, we can take a stair lift out of a property and use it elsewhere. If it is a straight stair lift, for example. It's more difficult with your curved stair lifts because they are obviously purpose-built for that property. So that way it becomes then a more of a major adaptation because of the cost implications, etc. But we'd always look to allocate it to somebody who needs those adaptations in the first place. Absolutely.
Are you happy with that, Sonia?
I am happy with that to a degree, although you can see my concerns as a Valleys member, that it is, and it is one of my concerns around the impact assessment as well. I think there's an issue here with that sort of property particular in areas in valleys. So it becomes a real issue sometimes up here, and disabled people or people who become disabled not wanting to move away from community and background. So that would be my concern.
Thank you. You had a question about rent affordability? Yep.
I've done the rent affordability, but I'm looking very much at then 7, 10, 11, which is there may be a review of the assessment of need despite the fact that other relevant information has not become available. Now, the concern is what would trigger such a review? What would make that possible? Because there seems to be, if there's no additional information, then surely the original information stands. It sort of, it doesn't seem to make sense how that would work. And I wondered if you could just clarify.
Chris, did you want to do that one?
Yeah, of course. Yeah, no, so this was included in a document because there were previous occasions, unfortunately, where an inappropriate band had been awarded to an application, for example, because it was based on the wrong information. So when the new information came to light, or the right information came to light, then we could never amend that band, because the policy didn't allow us to look back at a case and say, hang on a second now, we got that wrong. You know, we took into account these circumstances and we shouldn't have because they weren't right. Now, it could be because, for example, somebody said they're overcrowded and so they awarded a higher band, but actually they weren't, because then we determined that that wasn't the case, that we got it wrong. So we couldn't go back then and review the same circumstances, saying, hang on a second, we got it wrong this time, we want to put it right now, because that person then would be given a higher band award because we got it wrong and they shouldn't have been, for example. So that obviously had an impact on other applicants as well. So sometimes we do get the assessment wrong. And this was put in there to allow us to look at cases and say, hang on a second now, on review, we shouldn't have done that, you know, because that wasn't the right circumstances. I'm not going to say it's going to happen very often. It's going to happen very, very rarely. But it has happened once where we've seen it and said we can't change it.
To add to that as well, it's where there's a change in circumstances and people don't always tell us about the change in circumstances. And therefore they are within the banding system as requiring a certain type of property. But had that change in circumstances been known or taken into consideration, then actually they are incorrectly banded. So it is to allow for when that happens that we are able to revisit that.
If I may, Chair.
Yes, certainly.
It's the clarification for me, though. I understand what you were saying, Chris, quite clearly, and it's obvious there's a need for being able to review the decision in those circumstances. And but it's irrespective of whether or not new information is available. So what would trigger a review if there's no additional information? Is there a time limit? Is there because I don't feel it's clear there. It would concern me if that carried forward.
Can I just clarify, Sonia? Sorry, can I just clarify the point? Is it 7.10 that you're looking at?
It's the bottom of page
7.10.11, Claire.
7.10.11.
Bottom of page 40, last bullet point.
Right, sorry, I'm on the wrong page.
So yeah, so for example, if we were matching somebody to a property in terms of when we talk about adaptations, for example, because the point does there cover the adaptation side of it as well. So if we had an application now from somebody, we assessed it as they needed adaptations, etc. They were given an appropriate band. So for example, they were given a gold band award. If then we came to do a match outside Homes by Choice, for example, and we said then, all right, this person's come up for it, they're a gold band, they're next for it. If upon reviewing that case, then at that point in time, we determined, hang on a second now, there's already adaptations in their home which we didn't take account of previously, so therefore they shouldn't have that higher band award, the gold band award, then it's something we could review and look at and change. It allows us an opportunity to look at things in more detail at a point in time. It could be an allocation point, for example, it could be a matching point, it could be a bid-in point, or it could be where somebody tells us something, when we review their application, where something's changed and we said, all right, that's wrong now. We didn't realise that, or we weren't told that in the first place, then we would be able to change their band accordingly to their circumstances.
The other thing we do is quality checks. Get quality checks in reviews. So, for example, we do an element of testing, an element of peer reviews. That type of review where that would come into play there as well. This isn't about someone thinking they're really close to getting an offer and all of a sudden we're going to whip it from beneath them. It's about making sure that everybody's had a fair assessment, it's the right assessment, and therefore if a property becomes available, it's those which most need it are going to get it.
Thank you, Chair. Is it possible that can be clarified? Because I think at the moment it looks as though you can review at any time for no particular reason.
Yeah. We can add additional information to that one.
Thank you.
Great, thank you for that. Right, you'll be pleased to know, officers, that we're on the last page of our list of questions. Okay, it's about homelessness now, and I know we touched on this right at the very beginning of the thing, but on page 35, 6.11, and again on page 44, 8.6.2, we've got this mention: if a homeless person is offered suitable accommodation but refuses it for any reason, this will bring to an end any statutory homeless duty. And then on page 44, this will discharge any future duty to assist under homelessness legislation and determination of temporary accommodation. I just wondered what happens then if somebody has been refusing the accommodation. What happens to them then, bearing in mind the Welsh Government direction, particularly during the pandemic?
The pandemic, I guess, presented us with extraordinary circumstances, and I think to a certain degree that had to be accommodated and reflected in what we did during that period. With regard to these particular points, this will be a point which your council colleagues in the housing options team will be particularly interested in and wanting this included in the document. So I don't know whether Rob, Angela or Gareth want to comment on this, because this really is about the council as well being able to move people out of interim accommodation and get that churn, get them into accommodation with us or POB or whoever, so that it frees up more interim accommodation. So we wouldn't want a position, as I guess the council wouldn't want a position where you've got someone in interim accommodation who's just not bidding for a property, or who bids and then says, oh, actually, I don't want that. I think I'll stay where I am and wait for something else to come up. So I don't know if there's any, well, either Chris or any council colleagues who want to come in on that point too.
Is there anybody wants to come in? Robert, are you wanting to come in? Yeah.
Yeah, that's fine. Yeah, exactly right what Claire's saying. What that is avoiding is, like Claire said, is people say, no, I'm comfortable here. I don't want to move on anywhere else. So we got to get to a point where, of course, our team will support them, encourage them, see what the barriers are, work with Titanium, work with the other LSLs to try and really persuade these people to move on. But it gets to a point where we've done all we can and they're still refusing or not bidding or whatever it is, for whatever reason. It gets to a point where we have to discharge the duty. So then we basically say to them, well, we've done all we can, you're refusing everything we've given you, back over to you.
John, I can see you indicating. John Hodges.
Yes, Chair, if I can just say with regard to the point which was being raised about the Welsh Government's instructions during the coronavirus pandemic, because it's very difficult to insert in a policy or scheme reference to something specific like that, there is a clause which was inserted into this document, making it very clear that it has to be read and interpreted in accordance with the law, so that if now or on some future date there was a temporary restriction upon social landlords or local authorities exercising their normal rights, that is catered for by that clause within the policy.
Thank you for that, John. I really did want clarification on that one. Right, okay. Councillor Edwards, perhaps we should ask this question as a duet because we both raised it. Do you want to ask about page 55? Right, it's
can you clarify what we're talking about?
Okay.
Because my pages are different.
I'll ask it on Councillor Edwards' behalf, but we both wanted to know what a frontier worker was.
Oh, can I come in before that then, Chair?
Yeah.
Because I've got it on page 51. Sorry, if I could indulge me a sec.
Okay.
At the top of that paragraph that you're asking that question about.
Oh, yes, I've got it.
It's 2. The following are not to be treated as persons from abroad who are ineligible for an allocation of housing accommodation pursuant to paragraph 1A. Now, I read that paragraph, that sentence about 10 times, and I still couldn't make any sense of it really. So perhaps you could sort of work your way through that. But as you said, almost at the bottom of the page, you've quoted about a frontier worker, and I thought we were in Davy Crockett land or something. But you know, as Chair says, what is a frontier worker, please? Thank you.
Okay, to answer the first question, the frontier worker, and I guess this goes all the way back to our original discussion at the opening of the meeting around there are certain things which we need to include in the document and certain pieces of legislation that we need to include. And I think probably if we had our own way, everybody in this meeting would try and interpret that in a much easier to read and understand manner. So a frontier worker, and I had to Google this for myself, is an individual who lives in one country or EU member state, but who travels to work regularly in a different country. They could be employed or self-employed in the UK, but live somewhere else. So that, in a nutshell, is the definition which is given of a frontier worker. I have to say, I've never come across this in terms of an allocation. I don't know whether you have, Chris.
No. I think in terms of the legislation regarding immigration status, we rely heavily on our legal advisors to give us the most up-to-date information, and that's what's happened in this case. You know, the policy has been updated by both ours and the council's legal advisors in terms of immigration status, which accounts for the changes in relation to, for example, the frontier workers, Afghan nationals, etc. So, yeah, we rely on others, thank goodness.
Right, that is not what I thought it was. I thought it might have been a frontline worker, and I was thinking about the pandemic and about the nurses on the line. But you know, if you're not told what it means, then you just have to use your imagination. That sentence, that bullet point, sorry, the sentence with number 2 at the beginning, I can see what you mean, Carolyn. The following are not to be treated as persons from abroad who are ineligible for an allocation of housing accommodation pursuant to, well, forget the pursuant bit, but I presume it means these people are going to be eligible because of the following reasons. It's almost like a double negative. I don't.
Sorry, can I just check what page we're on?
Right, we are on page 51. We've gone down to 1, we've come down to 2. The following are not to be treated as persons from abroad who are ineligible for an allocation of housing accommodation pursuant to paragraph 1A, and then it goes through that lot. I can see the confusion, Carolyn. Oh, if it's just legal jargon, we just have to hope that people understand what it means.
Let's check with our legal advisor to see if it can be written any simpler. If we can write it in a different way, then we'll look to write it in a different way. If it's something they tell us has got to be in the document, then our hands will be a bit tied. But I'm happy to go back and say, look, is there another way of writing that sentence?
It's a bit tortuous, I think.
Mm-hmm.
It is a double, I understand, yeah.
Yeah, there's almost like a double negative there. Right, excellent. Yeah. Okay, we're getting there. Carolyn, you wanted to ask about bedroom allocation. Councillor Edwards.
Thank you again, Chair. Yeah, page 69, we've got the bedroom standard chart with crosses in. And then on page, well, it says 65, but I'm not sure if the page number is slightly different because the page before it is 72. But you've got another chart in blue with ticks in. So that's very confusing because do the crosses mean no? And I think they mean yes, but why do we put ticks in rather than crosses? And, you know, and balance it up then, match it up with the blue chart that's got ticks. But I found those charts a little bit confusing, particularly with the single adults and so on. And the other question I wanted to ask about the bedroom allocation is, I think that's on page 61. It states that 2 children under 10 can share a bedroom. Well, surely, you know, in this day and age, any child over 6 months should be allocated his own bedroom. Thank you.
So have you found the 2 charts that Councillor Edwards is referring to? Because I've just found them.
Yeah.
One is on 69 and one is on 73. Yeah?
Yeah, that's correct. Those are the 2 I've got.
So can you answer?
Yeah, would you like to respond?
Ticks and the crosses.
Yes, Chris?
Yes, of course. Yes, of course. Yes, I'd agree, Councillor Edwards. It does look very confusing. The 2 charts have different meanings. The bedroom standard chart on page 69 refers to us assessing an application to determine whether or not overcrowding exists. So what it says there is for those purposes, and this is based on the government rules around sharing and bedroom tax, etc. But the government rule says 2 children under the age of 10, for example, regardless of what sex they are, can share a bedroom for your bedroom tax rules. So in other words, then, that you wouldn't get an extra housing benefit, for example, for an extra if you lived in a 3-bedroom. But we look at that in terms of overcrowding. So that basically, that chart is looking at that aspect of it. So if we've got somebody who applies, for example, with 2 children who are under 10 of the same sex in a 2-bedroom accommodation, that means then they don't get additional different housing need factors for overcrowding. However, chart 2 looks at what they can be accommodated in according to our shared letting scheme. So in other words, if I applied and I had 2 children, a boy and a girl under 10 in a 2-bedroom flat, then I would be classed as having no housing need in terms of overcrowding. However, I can be considered for a 3-bedroom accommodation under the scheme. So I can still go for a 3-bedroom property, but I wouldn't get additional housing need factors for the fact I've got 2 children sharing a bedroom. Also, then it's based going forward on affordability as well, for example. So I may say I want 3-bedroom accommodation, but I may not be able to afford it because I can't afford the top-up charge for the bedroom tax element. Because I would still be classed as only requiring 2 bedrooms then until one of my children then attain the age of 10, for example. So it is a bit confusing, but it's got 2 elements to it. Yeah. One is the assessment element, and 2 is the allocation element. And that's what really this scheme is about. It's about the application, the housing assessment, the need factors, and then the allocation assessment. So it's a 3 stage approach then really, and this is the second stage in that, the assessment stage.
I actually understood.
We'll look to make that clearer.
Okay. Sorry, Claire. Claire, do you want to come in there?
I was just going to say, having had this conversation, though, we will look to make that clearer within the document itself.
Carolyn, I understood that. Were you okay with that?
Yes, yes, thank you. I understand it better now. Thank you.
Great. And Suzanne, you're indicating.
Thank you very much, Chair. Yeah, just wanted to echo Carolyn's thoughts on the fact that, in this day and age, we should really be giving children separate bedrooms. And I understand totally how Titarian officers have to comply with the rules laid down by government. But a question along the lines of that is, if somebody applies and they have children, and within a year or so, those children are going to be above that age, do you take that sort of thing into account? Because you wouldn't want to move a family into a property and then have to move them out like within 9 months because one of the children have gone over the age range. And I understand how difficult it must be for officers to allocate in these conditions, but do you take that into account? Thank you.
Do you want me to answer this one?
Yes, please.
That we certainly would. And when you said about the rules of government, our policy does say, look, we will do this flexibly. If you need an extra bedroom, we will allow, but we need to look at the affordability element of it because of the bedroom tax. Yeah. Now, we quite often come across this where somebody is perhaps pregnant, 20 weeks pregnant, and they're down for a 1-bed property, but actually they're going to need a 2-bed property pretty soon. So we're not going to want to move anybody in for them to move out or put in a transfer 6 months later, for example. So we do look, and this is one of the ways in which we can look to support the applicant or the tenant to make a claim for discretionary housing benefit through the local authority. So if actually for a certain period of time, a very short period of time, they need that top-up allowance because they're not going to be able to afford to live there, but in 6 months' time or a year's time, it's going to come, we will support them and we will help them put in an application to be considered by the Housing Benefit Department in order to cover that cost if it's an affordability issue. Sometimes people can afford it, perhaps they're working and on part benefits, that type of thing. So it's all on the individual cases, but we do try to be quite innovative in how we can look to support them to get those what they need.
And if I may come back, Chair, I totally understand the dilemma and I'm very pleased to hear that result. But I think Caroline would probably agree with me is that, a bedroom is not just somewhere to sleep. It's somewhere to have a bit of private space away from the family to do homework, that type of thing. So we're all up against it when these silly rules are imposed on us by government. Thank you very much.
That's a very good quote. And Carolyn, you wanted to say something about the valleys?
Yeah, thank you, Chair. I think I've taken over the meeting today. It's the end of at the end of our agenda where it says the community's impact statement states its policy has no impact on valley communities. And Sonia mentioned this earlier on, you know, I think in the valleys we probably have stuff has more impact on us because of the lack of housing and so on. So, you know, sometimes I find, and I think we've discussed this in council, these statements, they seem to be a catch-all and, you know, just dolloped on the end of the report, where really I think that this policy will have a big impact on valley areas. Thank you.
Anybody want to respond to that? Or you just want it to be noted that we do seem occasionally to get statements that seem to have just been put in because that's what you put in when it says Valley's impact assessment, and perhaps we're querying whether this is thought through in any depth. But I think we will just hope that that comment has been noted, if that's okay, Councillor Edward.
Yeah, yeah.
And John, I can see you indicating, John Hodges.
Yes, again, Chair, because I did have some input from Neath Talbot's side for the legal input, and whilst this has been totally properly written so that people can gain an understanding of whether they're likely to qualify, what they might be considered for, how it all works, there is an important clause in there near the start which makes it clear that where a discretion remains, we're not going to, this isn't going to tie officers' hands. So the example which was given about somebody who is about to qualify for a different category of housing because of pregnancy or their children, a child is about to become older, that can be legally and properly provided for without departing from a fairly clear system of allocation.
Thank you for that clarification. Now, you will be pleased to note that that comes to the end of our list of questions that we came up with in pre-briefing. Is there anybody on the committee who has anything they wanted to ask that they haven't had a chance to ask? I can see Carolyn indicating, Councillor Edwards.
Again, yeah. The first, to go back to the beginning of the report, and I think this is important, we haven't had anything from our officers this morning, but the first sentence of the report states the council has transferred all administrative rights to Titalian. So do we feel that that gives the council enough control, because we have obviously obligations to residents too. So, you know, where do we feel and our officers feel as regards to that? Thank you. I finished now.
Yeah, I think that's a good question on which to answer. I think somebody isn't muted. That's a lot of paperwork. Can we just check we're all muted? Oh, thank you. So basically what Councillor Edwards is saying is she's going right back to the very beginning of this report, which is talking about control, contact and whatever. And would a council officer like to respond to Councillor Edwards' question? Anybody? Do you want them to repeat it, Angela, or John, or Robert?
John's got his hand up there. Councillor Purcell.
Robert?
Sorry, John's got his hand up.
Go on, John.
Everybody's right. Okay, we know what the question is. John, would you like to answer?
Well, sorry, yeah, I was busy doing something on my other machine at that moment. I missed the question, but if you'll repeat it, I'll have a go.
I thought so. This is what happens at the end of, well, as far as the pre-briefing is concerned, the end of 3 hours. Right, Carolyn, would you like to repeat that for everybody? This is our last question of the day.
Okay, the first sentence section, page 13, 1.3. The report states council has transferred all administrative rights to Titalian. Does this give council enough control if they need it? Thank you.
Now is that clear?
Yes, I'm just getting it up on my screen.
That's okay.
Just bear with me. This is back to page 13.
We're getting a little bit of fatigue of just looking at the screen apart from anything else.
Right. What's the clause number? Sorry.
It was page 13.
1.3.
13.
13.
Page 13, 1.3.
Right, bear with me. Page
Yeah.
13, 4.3.
1.3.
It's the third bullet point down on page 13.
Right. I'm gonna have to go in, and I'm in the draft. I'm gonna have to pull up the real one. Bear with me one moment.
It's okay.
Can I just add something from an operational point of view while John is doing that? As far as we're concerned, from the housing options point of view, it works perfectly well. It's something like the guys have explained. They come through housing options, we refer them into Titarian deal with it from their end, and they work very closely with us anyway. So that arrangement works perfectly well for us.
John, that might be all that Carolyn Edwards needs to know. She just at the very end of this very long and detailed meeting, she just wanted to check, I think, that this is working okay, that this has been transferred, that it is working smoothly. Are you happy with that answer, Councillor Edwards?
Yes, very satisfied, considering our officers are satisfied. Yeah, thank you.
John, that lets you off the hook. You're okay.
Yeah, I'm grateful, Chair. No, but it is working well. Because of the agreement whereby the council did delegate its housing function to Titarian, then that does place some restrictions upon the extent to which we can dictate. But as Robert has said, it's working well. We're all working together, trying to deliver the same aims and policies.
Right, okay, ladies and gentlemen, as far as I can see, that's it. The whole point of this was for us to be able to see the draft letting policy, to ask questions and to have our observations, comments, questions noted. And from that point of view, I think it's been very worthwhile. I can see the cabinet member indicating if we could just take his comments before we finish.
Thank you, Chair. Just my name was mentioned twice in conversations earlier on by Chris and John. I'd just like to congratulate the Scrutiny Committee. It's been a meaty document, and in all fairness, I had 3 questions, Chair. One was on youth accommodation, which was covered. Adaptions, which in all fairness, Sonia had a good go at and was covered. And homelessness, which was covered. So, I've been through the document. It is quite a long read, difficult read, I suppose, in some respects. But I've got through it. Claire, Chris, I like Arwin. I haven't seen you for a long, long time. Nice to see you here this morning.
You too.
And can I take this opportunity, both, to thank you for the support and the work you've done with us to get through this difficult time with regards to homelessness. It is greatly appreciated. I've worked closely with Rob and Angela on this side, and it's been a challenge for all of us. There are things we could have done better. There's the things we've learned from. But having said that, we didn't know we were going to get into this situation before, did we? So I'll just close on that note. But can I thank you all this morning? Thank you very much.
Can I also thank you, but also to thank the committee for persevering in reading such an incredibly long, complicated and detailed document. I am proud of this committee in that we don't just skim read things. We do dot the I's, we do cross the T's, and therefore there is some point in spending 3 hours on a Monday morning going into this in such detail. So thank you very much, particularly those who submitted the questions in advance and have gone into such detail in this. And I think if those little hands are about to go down, which is John and Councillor Richards, are those...
Right, Chair, can I just come back? Can I just say that I likened this to a public inquiry? In all fairness, 2 officers have been totally grilled, and well done to them, because they really handled themselves extremely well. Thank you.
It certainly felt like it. It certainly felt like it.
Thank you.
Right, everybody's hands gone down. Right, that's it. Thank you very much, everybody. Thank you, Titarian Office. Thank you, Council Officers. Thank you, Committee. And I'm drawing this meeting to a close. Goodbye, everybody. Committee, see you Thursday. Okay, bye.
Thank you.
Thank you. Take care. Take care.
Bye.
Bye-bye.